Hello, my name is Robert Goodwin, and this is Law on the Line. I would like to invite and welcome my guests for today's segment, starting off with Zanaya Maynor of Zanaya Maynor Law, located in Edison, New Jersey. And welcome aboard, Zanaya. Zanaya is a practicing attorney, and she's also a member of the Middlesex County Bar Foundation. And she practices and specializes in real estate and business law. And last but not least, since we only have two people here today, is E. Martin Davidoff. And Marty is a CPA and an attorney with Prager Metis CPA, a national firm, and he is the partner in charge of the National Tax Controversy. And welcome aboard, Marty.
Great to be here.
And at any rate, today's segment is going to be all about liens, and including IRS liens and all the other kinds of liens that could exist when we are dealing with real estate and other property. And every time I hear the word liens, when I'm dealing with real estate, I get nervous. And we all get nervous about IRS liens. And I'm going to throw the series of questions to Marty's expertise in the area of IRS liens. Marty, what should we all know about IRS liens?
Well, first of all, you don't want to have them. So if you don't owe money to the IRS, you're not going to have an IRS lien. But if you do owe money for the IRS and you don't respond to their early notices, they are going to eventually issue what they call a notice of federal tax lien against you, and that's a public notice of their lien on you. And usually they will file that in the county of your residence. And when it's not effective on property outside of that county, which is very interesting. It's not like a state judgment or any other kind of judgment. It's only effective on property in that county. So if you live here in Middlesex County,
yes.
If we're in Middlesex County and they own a property in Hudson County, they can sell that Hudson property and it's not subject to the IRS liens. Now, they may have to explain why they owe to the bank, why they owe money, but the lien is not going to subject them. So the IRS has to do two things to perfect the lien against the property. They have to file it in the proper county, and it has to be under the proper name. So if it's in my name of E. Martin Davidoff, as opposed to my company name of Prager Metis, a property owned by Prager Metis would not be affected. So even if you own 100% of a company, they look to who owns the property. If I own the property, a lien against my company will not affect it. If there's a lien against me, a property owned by my company will not affect it.
Many people are married, and husband and wife own the property jointly. And for example, if the property is owned in Middlesex County and it's husband and wife, but the IRS tax lien is against you, how does that affect the property?
Well, that affects the property. The property is still subject to the lien, but then what we'll be talking about later is how you get a discharge of the property, and they will usually accept the equity from the husband's half of the property only, and that would be part of a lien discharge that you go to the IRS and say, listen, you don't have an interest in the wife's half, you only have an interest in the husband's half, so you need to let that money go and allow us to sell, but you do have a lien on the husband's portion. And we'll be getting that later when we talk about liens beyond all the other liens that beyond the IRS.
Okay, so one other question.
Sure.
If the property is located in, let's say, Hudson County, the lien would have to be filed in Hudson.
Correct.
They have property in Middlesex as well.
Mm-hmm.
Is it correct that the IRS would file in both counties as to both properties?
I mean, they should be if they know about both properties. Often the IRS doesn't know about all the properties. They're issuing the lien before they know any financial information about the people. So they'll file, and it's called a Notice of Federal Tax Lien. It's a very formal document. They'll file it in whatever counties they think are necessary. But what happens in reality, when the lien is done by a local revenue officer, when the case gets out, larger cases, and they get to a revenue officer, the revenue officer is doing an investigation of where the person owns property. And sometimes they'll miss a property. The taxpayer may own a property in Texas, and the IRS only files liens in the New Jersey counties, but doesn't file in Texas. And they could sell that Texas property without consideration of that notice of federal tax lien. So yes, the IRS should file in all the counties that you have property, but sometimes they don't know to, or their systems don't allow them to know about that at the time.
And one last question in this regard. Does the IRS learn where the property is through the tax filer? Information on the 1040? Is that how they learn?
Well,
or they do independent searches?
You're supposed to give them often if you owe money, they go to you and say, listen, we're going to levy your accounts unless you make a deal with us. And as part of making a deal, you need to make full financial disclosure to us. And there's a form 433A, which is a form that the IRS gets you to tell them what assets you have. And you would list all of your real estate on that. They have a specific question. But short of them getting it from you, they may do searches, they may look up your name, they may look you up on LinkedIn, see if you're a real estate developer. They have ways to do searches of real estate in your name.
Interesting. Now, Zanaya, you represent private individuals in residential real estate. Is that accurate?
Yes, absolutely.
Do also commercial real estate, I am
do.
assuming. So, you are representing a buyer, and I tell our audience what you do to ascertain whether or not there are liens, and then how you deal with the liens, if any are found.
Well, you're right in starting the question and what I do and when I'm representing a buyer, because that search is different whether I'm representing the buyer or the seller in the transaction. And that's because the buyer's attorney is going to be responsible for obtaining what's called the title insurance commitment. And in that title insurance commitment, that's usually where we find out whether or not there are any liens against the property that is the subject of the transaction. In which case, sometimes it's a little too late in my eyes, because that's why we have people like Marty here to take over from there. And that's because my goal is to get us to the closing table as soon as possible. But if we've got a lien there as a roadblock on the way to the finish line, then the first thing that we need to do is to contact a tax specialist to teach us and tell us what we can do in order to get rid of that roadblock on the way to the finish line.
But there are liens other than the IRS, and
Absolutely.
I know you provided me with a list of some of those liens. So what are the common liens that you find in a title report that would affect real estate?
We have child custody liens, tax assessment, whether that's township or HOA, creditor liens, and those are really the major ones there. And
child support is a fact of life, and it affects many buyers and, for that matter, sellers. What information, how do you learn about a child support, a lien or arrearages, or how does that come about?
Well, the best way for me to find out is to do my due diligence at the beginning of the transaction. And that's because when it comes to child custody liens, they are paying those installments on a monthly basis. And so the goal is to ensure that there are no arrears at the time of closing. And so to wait until we get to the closing table would be too late if they've got 2-3 months backed up and they don't have the funds to pay off that lien. It's not possible to close on a property with an open child custody lien, whereas other liens you could.
Is that automatically, child custody lien, a judgment against the property?
No.
No, it's not.
No.
And is there a certain dollar amount before a potential buyer or seller, for that matter, unless you use a buyer who's applying for a mortgage, is there a certain dollar amount that would constitute a lien against the property that they owe?
Well, if we're talking just generally speaking, yes, but for child custody, no, because a child custody, it could range anywhere from $50 a month to a couple $1,000s a month, just depending on their financial circumstances. If we're talking about a creditor lien or an open mortgage lien, then we're talking, upwards of $20,000.
I see. And that would be through either judgment that you find in a judgment search or IRS search or a homeowner assessment search and the like.
Yes.
But on the child custody, there's no tolerance.
No.
They won't let you close even if it's $1.
No.
And you have to get a waiver from them and proof of payment.
Exactly.
Is that correct?
Exactly.
And I know there's all kinds of negative implications. If you have child custody liens, you could lose your passport, or your right to renew your passport, your driver's license could be affected, et cetera.
Yes.
So, Marty, when there is an IRS lien, and let's say Zanaya calls you up and says, my client, Marty, has this what appears to be a $50,000, $60,000, $70,000 IRS debt, and they're not going to qualify to purchase this property, or for that matter, the seller. There's this lien against the property. What can we do? How do you go about mitigating that?
It doesn't even require litigation. There's a process where the IRS, and here we're dealing mostly with representing the seller, because the buyer can buy a property with an IRS lien, but the seller can't sell the property with the IRS lien. So the seller has an IRS lien, and the first thing to say, is there enough equity in the property to pay off the IRS? If there is, it's very simple. You get a payoff letter from the IRS, they sell the property and they give it to the IRS. That's not the problem, all right? The problem is, and by the way, if for some reason the person didn't owe it to the IRS, they can always go for a refund up to 2 years later and file for a refund. But let's say you have $1,000 equity in the house and you owe the IRS $100,000. How are you going to close?
Yeah.
Well, it's actually fairly standard that the IRS says the IRS interest in this property is only the amount of equity, $1,000. So what happens is there's a process by which you go to the IRS advisory people, you file a form 14135, which is an application for a certificate of discharge.
I think you provided a copy of that
yes.
for me.
And you can get that form on irs.gov, and you file the application for discharge, and you basically tell the IRS a few things. First of all, you say, look, here's the fair market value of the property. Here's the contract from an unrelated person. Here's an appraisal. You'd have to get an appraisal. Maybe here's a tax bill. And you prove that the valuation is correct. The second thing, if there are any senior liens to the IRS, you provide that information.
What would be senior to the IRS?
A mortgage loan to buy the property is always senior to the IRS. So a purchase money mortgage loan, even if the house was purchased after the IRS lien was there, they're senior. Mortgages that were incurred, or any kind of debt that was secured, or judgments that were in time before the IRS, they're senior. So
a judgment creditor's judgment would be senior to the IRS?
If it was if it was filed before the issuance of the notice of federal tax.
So that first in time is it prevails as well.
It's very, very critical. So what would happen is, if you show the IRS that their interest, if they sold the property tomorrow, they'd only get $1,000, then they will accept $1,000. They'll discharge the property. You still owe the other $99,000 to the IRS,
That's right.
But the buyer walks away free and clear with that property and doesn't have any lien because he's gotten a certificate of discharge. The nice thing about this is that the IRS usually works very quickly on this. It means in your situation, whether you're the buyer or seller's attorney, you have to get that title search early and give me a closing statement at the beginning, because I have to give a sample closing statement to the IRS, and it's got to be pretty accurate. And I got to give them a contract of sale, and I've got to give them all the numbers. I have to lay out the numbers for them, and I usually do that in a letter.
And you did that even in the sample documents you provided to me, which was basically a draft or sample, a closing statement. This is what you give to the IRS?
That's what I give to the IRS, exactly what you have in that package. And so what happens is, you give that to the IRS. You're dealing with a single advisor locally here in New Jersey. They're out of Freehold, or at least their office at Freehold. Everybody works remotely right now.
Right.
But you're back and forth. And so you file this in a centralized lien area, and the address will be put up, but I'll announce the address. It's actually, you file it into the Internal Revenue Service in Florence, Kentucky, and there's a fax number that you send these into, and it's in the instructions, but it's 844-201-8382.
Yeah, you have it.
So your Form 14135 and all the attachments go to 844-201-8382, and then in about a week or two, you'll get a phone call from a local advisor who's working in New Jersey and knows the New Jersey laws and knows how New Jersey liens work. And that person will work with you to finalize and get you, he'll tell you, he or she will tell you, are there problems with it? But ultimately, usually what we do is when we give them a complete package being all the materials I've mentioned to you earlier. We provide all of that material to you, the contract for sale, the appraisal, all of that information. We get into the IRS. Usually within 30 days, we have this resolved. And so somebody can sell their property for no money to the IRS if they're underwater, or for a much lower amount than they owe the IRS. And it's a great problem. And most people don't know. They figure they can't sell their house if they owe more money to the IRS and can't pay off the IRS. You don't have to pay off the IRS to sell your house if your house doesn't have the equity.
And the IRS does not forgive the debt. You mentioned that earlier.
That is correct.
And I have a question to you, Zanaya, in this regard. Marty has said something about it really affects the seller, but what about the buyer? If there is an IRS debt that when you're doing the title search, how is the buyer going to qualify for a mortgage if they owe the IRS money? Is there a correlation between the two?
Well, if we're talking about a lien on the property that the buyer is purchasing, Marty brought up how critical that timeline is. And the reason why that's important is because especially in times like this, when the real estate market is so up and down, buyers are submitting offers based upon their ability to get in and out of the contract within 30 to 45 days. And
is that because of mortgage requirements?
Exactly.
I see.
Exactly. And so if we're going under contract on the first of the month, it's critical for the real estate attorney and myself to get that title report as soon as possible so that we can see what's up against the property. Because if we do need to enlist a tax specialist and he needs that sample closing statement and we're looking at a 30-day window, I mean, it usually takes about at least 2 weeks for a title report to come back. So that's halfway through that transaction already.
Right, but in a typical title report, does an IRS lien against the buyer who's now looking to buy the property is free and clear of liens. But when you get it, does the bank learn about this when they're doing their preliminary mortgage application review?
Well, okay, so two things. On the title search that you're doing, it's on the property being sold.
Correct.
The credit report by the bank, and IRS liens don't show up on credit reports. But the buyer has to be providing an honest assessment of their finances and should show that. The interesting thing is, if the bank lends them money, the bank goes ahead of the IRS because it's a purchase money mortgage, and they always go ahead of the IRS. But it's really part of, on the buyer side, if the buyer has a notice of federal tax lien filed against them and they owe the IRS money, that's just part of their overall financial situation. Are they going to give them a loan? Are they going to give them a loan if they owe credit cards? Are they going to give them a loan if they owe the IRS? It's the same analysis. The IRS is not going to stop the sale, all right, when the buyer owes money. They're not going to have a lien on the property.
Gotcha.
As a result. That'll impact the seller or impact the seller's money. But if it's the buyer who owes the money, it's like any other credit defect. And the big thing is, and just to bring it back to the seller, what Zanaya's role is, and she tells me she does this all the time, she goes through an extensive set of questions, trying to find those liens ahead of time before the title report says, do you owe money to the IRS? Do you owe money for child custody? She goes through her checklist, and she pretty much knows if the client's been honest with her, and they can start cutting it off at the pass.
Is it statutory, either one, this question's to either or both, is it statutory that the IRS doesn't, the lien or the debt doesn't appear on a credit report?
No, it's not statutory. Here's what happened. They used to be on the credit report until about 2017 or 18.
And what happened?
What happened is the credit reporting agencies, had this great idea. They said, well, the IRS started only putting the last 4 digits of the Social Security number on these notice of federal tax lien. So they said, well, it's possible that 2 people with the same name and the last 4 digits of the Social Security number, live at the same place, and we may be putting this information on the wrong credit report. Now, that's almost impossible.
Right.
And the IRS actually has a solution to that. It's called a certificate of non-attachment, where they say, okay, we have a name mix-up. We're going to give the closing a certificate of non-attachment saying it doesn't attach to Tommy Jr. because the lien's really against Tommy Sr.
I see.
But basically, the reason it's not on the credit reports is a private industry decision not to put them on the credit reports, nothing statutory.
I see. Now, I read that the lien lasts for 10 years. Is that accurate, the IRS lien?
Sort of.
Sort of. Explain that, sort
of. So the IRS has 10 years to collect its taxes generally. It's called to a date called the collection statute expiration date. And if the lien was filed at the beginning of when the IRS can collect it, they'd have 10 years. But sometimes the liens get filed a year later, 2 years later, 3 years later. But on the notice of federal tax lien is a last day for what they call refiling. Now, that date can be extended if somebody, if the IRS is put in the position that they can't collect their taxes. So if somebody goes to the IRS and declares bankruptcy, IRS can't collect the taxes during the pendency of a bankruptcy. If somebody asks for an installment agreement, they can't collect. So the time, or they do an offer in compromise, so the timeline gets extended. So generally, 10 years is the rule for how long the IRS can collect, but it could be extended, and depending upon when they put the notice of federal tax lien and they file it, that lien, may have been filed years later, so they may only have 7 years, 8 years, some shorter period.
Can the lien be renewed?
The lien can be renewed only, well, actually, the lien can be renewed if there's more time in the statute, like somebody extended the statute by one of these methods.
Right.
That's one way. The other thing is, at the end of the 10 years, or before the end of the 10 years, the IRS can say, hey, Bob, you owe us $300,000, and you have that real nice house and whatever, and we're going to put a judgment on you. We're going to sue in federal court and ask that the court place a judgment on you. And once they place a judgment on you, they have another 20 years to collect. That doesn't happen often, and it doesn't happen, with smaller amounts that are owed to the IRS.
So, okay, now we're maybe segue to the judgment part. And Zenaya, obviously, people get judgments, and that does constitute a lien. Mm-hmm. And what do you do when you are now representing a buyer, or I should say, you're representing a buyer, and you see in the title report that there are judgments against persons of same or similar name that pertain to the seller? How do you handle that so that we can get clean title for the buyer?
Well, in some cases, there are some negotiations that will take place at that point. And again, that just calls back to that timeline that we were talking about. Mm-hmm. And so if it's a small judgment, and I'm talking like a couple $1,000s, sometimes the parties will agree to close anyway with that judgment. And they'll do that by agreeing to hold money in escrow until either the buyer or the seller can satisfy that lien.
So escrows solve a lot of problems.
Yes, they do. But it does also require the two parties to come to an agreement. Sometimes one party or the other aren't exactly comfortable with doing something like that. And they want to purchase that property free and clear of any liens. But in most cases, especially now, the escrow is a buyer or a seller's best friend. And
the escrow agent pays the judgment.
Yes.
Have you come across, one of the judgments that, could arise in the state of New Jersey is we have an inheritance tax. Many states don't. I think most states don't. Have you ever come across a situation where you had an inheritance tax lien and that was, a substantial unpaid inheritance tax belonging to a purchaser or, to a seller, I should say?
No. In most cases, a lot of the liens that come up or judgments that come up will be actually open mortgages. And due to refinances, sloppy refinances, they kind of fall to the waistline. Banks will sell the mortgage over and over again. And if the bank doesn't exist and the papers are somewhere in someone's warehouse or garage.
In Oshkosh.
Yeah, they can't find the proper discharge to discharge the lien.
And what do you do then? How do you circumvent that, or how do you satisfy the lien if we don't know where the lender is?
Right. So temporarily, escrow. We hold the money in escrow until we can figure out or find whatever bank is responsible for containing those documents.
Interesting. Marty, you had a hypothetical, and I think maybe you addressed this. You said, for example, you owe the IRS $100,000 for the year in which the parties have filed, in which the notice of federal tax lien had been filed. Mm-hmm. But there's only $1,000 left at closing. And, you said before the IRS will accept $1,000
Yep.
and discharge their lien from the property.
Correct. That's exactly right.
And then the seller is free and clear the buyer can buy with confidence that there is no IRS lien affecting the property.
Now, what's very interesting is, when you make your application, say only $1,000 is owed to the IRS, all right, what happens is when the IRS actually closes, let's say there's $2,000 available instead of $1,000, all right? The IRS rules say not only do they get the $1,000, they get any excess. The seller can't walk away with any money if he owes $99,000. he's got to give any excess. And we do this on purpose sometimes. We'll actually estimate, if there's other liens on it, we'll estimate what it'll cost to satisfy that, and we'll estimate a little high, because you can always give the IRS more, but you can't give them less.
Gotcha. So if you owe them a little more and there's equity in hand, the buyer's not going to be, the seller's not walking away with that equity.
As long as they continue to owe the IRS money, that's exactly correct.
The IRS is always perhaps, are they one step ahead of us or not? It's not sure.
They're not always one step ahead of you, but in this area, they're very fair, and they'll do the right thing. I had a situation recently where, husband and wife owned the property jointly. Only the husband had the lien on him. And so when he passed away, and so what's the wife do? Because it was owned jointly. Well, in New Jersey, the IRS lien is immediately expunged, and you can write a letter to the IRS and say, IRS, give me a certificate of non-attachment. Tell me that the husband's lien no longer attaches to this property. And they will give you that letter, and it will be very detailed, and they'll do the right thing. So the IRS will do that. The other thing with liens, sometimes people will have a lien from years ago, and they paid off the tax, and it doesn't exist anymore. But they want to have something called a withdrawal of tax lien. They can have that history of the lien withdrawn from their record so that it doesn't exist. And this is particularly if you had a lien from before 2018 where it was on your credit record. You might want to get a withdrawal of federal tax lien.
Sounds like an expungement almost.
It is. It is sort of like an expungement. It basically says the original lien was a mistake, and and they take it off.
I see. Well, I mean, most of us are afraid to contact and work with the IRS, it seems.
That's why we have people like
right. No, that's correct. So, Naya, any tips that you have with respect to your potential buyer who is acquiring property about making sure that the asset they're acquiring is lien-free, and also that they're going to qualify for their mortgage? Any because we only have a few seconds left.
Sure. I think one of the things that I always tell my buyers and sellers is to build their toolbox. And that's just because I can't expect them to know everything, but if they could tell me as much as they know, and I could help them build their toolbox with tax specialists like Marty, loan officers, realtors. They've got all these people in their corner that are working for them to get them to the closing table. The best thing that they can do is be forthcoming in whatever information they have, such as I've got this lien, I've got this IRS lien, so that we can get them in front of the right people on time.
Okay, so to wrap it up, I've gotten the signal, but the moral of the story is be forthright with your attorney and work with a specialist who knows how to compromise and have a lien satisfied.
How to represent you properly.
How to represent properly, right? That is the key. Well, I thank you both for me, a very informative 30 minutes, and I hope that you enjoyed being a guest on Law on the Line. It was a pleasure having you today.
Thank you.
Great to be here.
Thank you.